Welcome to today's program titled Assessing Supplier Diversity Risks in the Post-Students for Fair Admissions Landscape. At this time, all participants are in a listen-only mode. For those of you who are logged in to the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down, as it will not be reread and it is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw, LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Annette Timon. Annette, please go ahead.
Thank you so much, and welcome to everyone for joining us today. We really appreciate your time on this important topic. As Kate shared, my name is Annette Timon. I'm a partner here in the Chicago office where I chair our People Analytics Practice Group, part of which includes advising employers on various diversity and inclusion issues. We're joined today by Barry Miller, who's a partner in our Boston office. He is also part of the team and has been deeply involved on these issues, especially with regard to supplier diversity issues and questions that have arisen. And then we're also joined by Brandon Dixon, who's an associate also in our Chicago office, who, again, we've been working very closely on DEI issues. On the next slide, we'll preview a bit the agenda so you have a sense of where we're headed today. We're going to talk about some background and where we're at from a DE&I perspective right now. We'll then fairly quickly pivot to the supplier diversity and Section 1981 issues, and then talk through some of the practical implications for what we're seeing. So as we see on the next substantive slide, we thought we would start the conversation by sort of previewing providing that high-level overview of the Students for Fair Admissions decision, because that really has shifted the landscape on the work that we're doing right now, even as compared to 6 months ago, and the questions that we're facing and the issues that are coming up. So we thought it was important to at least level set there. As you probably know by now, the SFFA case, Supreme Court decision there, this was an intentional, a direct use of race in admissions process. It came up in the education context for both Harvard and UNC, and the Supreme Court essentially ruled that colleges and universities were no longer permitted to engage in race-conscious admissions policies to foster their diversity in their student bodies. The holding raised implications under the Equal Protection Clause of the 14th Amendment, as well as Title VI of the Civil Rights Act. Now, that case, we've been tracking sort of a shift. We were seeing a shift in cases and sort of the allegations that had arisen, probably going back, I would say, at least a year and a half now. And so we've been tracking a lot of quote unquote reverse discrimination cases that we like to think about. But certainly, it's hard to believe that Supreme Court decision was June 29th. We're not even 3 months out from that decision. And since that time, there has been, a lot of discussion, a lot of concern raised, many employers, really trying to understand the implications as it relates to their employment, as it relates to the employment issues. Now, the reality is that from a legal perspective, nothing directly, implicated the employment context. There hasn't been a shift in the legal construct, the cases, the issues that we're seeing on the employment side, but certainly there are, signs of things to come, right? And so that's what we wanted to talk about today. And so in doing so, just keep an eye out. There has been so many questions that have come up on these issues that we're actually planning another webinar in October where we'll kind of just look at, kind of the quarter, 3 months post the Supreme Court decision and what the implications are. So we'll provide a broader context. But for today, we thought we would focus in a bit more closely on the supplier diversity issues. So if we go to, we'll see on the next slide, as I mentioned, rulings have no immediate impact on the legal standards that govern affirmative action in private employment. The 14th Amendment doesn't apply to private companies, and given the, legal frameworks that were decided, and frankly, the direct use of race, which I don't think necessarily applies in the employment context, there is some relief for the time being, but certainly there are signs to come. And in particular, the next slide, we called out pretty explicitly the concurring opinion, or a quote in the concurring opinion that we certainly think is important, that we've all been talking about, that has sort of, kind of given a lens towards what may lie ahead. And just, I'm just going to read it here, right? So to safeguard the civil rights of Americans, Congress chose a simple and profound rule, one holding that a recipient of federal funds may never discriminate on race, color, or national origin, period. If this exposition of Title VI sounds familiar, it should. Just next door in Title VII, Congress made it clear that it's unlawful for an employer to discriminate against any individual because of such individual's race, color, religion, sex, or national origin. And so that quote is one that, as employment lawyers, we've been spending a lot of time thinking about, and has, as well as the shift and the questions, the legal landscape that we're seeing and that I'll talk about in just a moment, has given rise to additional review and scrutiny. So let's look at the next slide. And here, just very, very high level, I'm not going to hit on each of these in a significant way, but there is significant pressure points that employers are feeling in multiple arenas. Certainly, there have been, I'm sure you've heard of the competing letters to various CEOs that were sent out by, first, 13 attorneys general's offices, and then there was, sort of the response letters from another 20. There have been, law firms have been the recipients of multiple targets, both from congressmen saying, hey, not only should you be ensuring that you are not yourself engaging in unlawful DE&I programs, but you should be mindful of the way in which you're advising clients and employers on these issues. There have also been attacks on, how law firms have looked at, or at least positioned, certain fellowship opportunities or internship programs. There have been various EEOC commissioners in their own capacity, either speaking, attending, participating in press releases, participating in, I can't remember if it was MSNBC or one of the talk shows, and provided information there. So there has been a lot of information that's coming from various EEOC commissioners in their own capacity. Then the other issue, though, has been the reverse discrimination litigation cases that have been filed. We are tracking many cases that have been filed most recently. And the interesting piece is that all of the issues that are being raised, whether it's the supplier diversity issue, specific initiatives that employers are undertaking, are being used as a holistic approach and will likely be used to support claims, especially when we talk about Section 1981, that really deal with intentional discrimination. And so all of that information may be used as evidence to point to the employer's culture and approach on various DEI practices and initiatives. So we've got the star here next to supplier diversity programs because that has been sort of an area that isn't often talked about as much in the employment context, but it is certainly an area vulnerable to attack. So I wanted to talk about kind of two more cases before we hit into the substance on the supplier diversity issue. In the next slide, you'll see that the first decision that we saw citing the Supreme Court SCOTUS decision was in Ultima Services Corporation versus the United States Department of Agriculture. Was really the Small Business Administration. They have, essentially have this decision struck down a portion of a government program that really, was there to provide opportunities to minority-owned businesses under the Small Business Act. This decision cited heavily to the SCOTUS fair admission case. They found a violation of the methodology under the Equal Protection Clause, the methodology under which the Small Business Administration used the methodology they used to identify those that were socially or economically disadvantaged. So the purpose of the program was to help certain groups. And one of the specific eligibility requirements was that you needed to be at least 51% owned and controlled by an individual who was, quote, socially or economically disadvantaged. So they had created this sort of rebuttable presumption that certain groups on the basis of race automatically qualified for that standard without any additional information. So essentially, race in some aspects would essentially qualify you for the program, assuming other criteria were met. The court did strike down that provision of the program, and what's interesting is at least right now they have temporarily halted the program in total. They're currently not accepting new application submissions under this 8A requirement. So that has been an interesting development. We liken that decision to essentially a supplier diversity program, except for the government, right? And so we see how the agency or how a court viewed that specific issue, pulling in the court's decision in the Supreme Court decision. The other case I wanted to highlight for you all is on the next slide. It is the Fearless Fund case. That one, it's an interesting one. It's the American Alliance for Equal Rights has filed a lawsuit, and we really don't know how that one's going yet, but it's certainly an important one that we are tracking. They filed it against Fearless Fund Management and really testing kind of the contours of private contracting. So Fearless Fund operates a program. They provide grants. I believe it's $20,000, assuming the eligibility requirements are met, and provides other perks, one-on-one mentoring programs. But that program allegedly is extended only to Black women. It's a very intentionally targeted program. Plaintiffs claim that they have members that could, who are ready and able to apply for that program, but they're ineligible because of the eligibility requirement that extends only to Black women. And they are arguing, they're bringing this case under Section 1981, and in particular, the intentional race discrimination that they contend applies with regard to the enforcement of private contracts. So we're watching that closely to see how these this case in particular shapes up, as well as the other cases that we are tracking. So on the next slide, just a couple takeaways, and then I'm going to turn it over to Brandon here. Is the Ultima case, certainly the Fearless Fund is not a necessarily Section 1981 supplier diversity case. Ultima was decided on equal protection grounds. But certainly the language in the opinion from the 1981 case, coupled with quotes from various advocacy groups, really do kind of foreshadow that supplier diversity programs are going to be targeted. We've got this quote here from Ultima, right? The facts in the Students for Fair Admission case concern college admissions programs, but they contend its reasoning is not limited just to those programs. So, we are watching cases. We do not think it's a stretch for courts to apply the logic and ultima to private employers, private companies, as they roll out their various programs. It's unclear how any employment law principles are going to apply, as Brandon will talk about some of the voluntary affirmative action that currently protects certain uh, activities, depending on how the employer rolls that information out, or whether those standards will even survive. I mean, that is one thing that we are certainly watching and thinking through the legal issues. So with that, I am going to turn it over to Brandon, who's going to give us some background and talk about the legal landscape under Section 1981.
All right. Hi, everyone, and we can go to the next slide. So today I will talk a little bit about how legal challenges to diverse supplier programs are likely to come under Section 1981, as Annette just mentioned, and how cases like Fearless Fund kind of inform that, and then kind of predict or at least start to predict what that might look like in the future. So, by way of background, Section 1981 prohibits race discrimination in the making, performing, modifying, termination of contracts. In order to bring a claim, plaintiff just needs to show that the defendant intended to discriminate against him or her on the basis of race, and that the defendant's activities concerning this making and performance, any sort of contract activities, that the defendant is sort of engaged in that sort of activity, and then that the defendant's actions interfered with the plaintiff's ability to engage in the specific contract activity at issue. Plaintiffs have to show, and it's a little bit of a high standard, but plaintiffs have to show that that it was but for race that they would not have suffered the loss of the legally protected right. So in this case, the ability to enter a contract, or to, if they lost a contract, that would be the protected right there. And to show this intentional discrimination, a plaintiff can point to direct evidence, they can point to circumstantial evidence, as Annette alluded to earlier, of discrimination on the part of the company or other entity at issue in the 1981 case. So it's a relatively straightforward claim, right? It's important to recognize kind of three basic tenets, right? That we're dealing with race discrimination only, that it's intentional race discrimination, and that it involves a contract, right? So, when you read these complaints related to these claims, they tend to be pretty straightforward. And a really important note is that the Supreme Court has ruled in Domino's Pizza v. McDonald that a person does not need to be party to a contract to be protected under the statute, that the law applies to prospective contractors as well, are prospective plaintiffs who are thinking they were going to be able to enter a contract. And that is particularly relevant to the topic we're discussing today, which we'll start to see on the next slide. So for the employment litigators on this call, Section 1981 is likely familiar to you. The majority of Section 1981 claims are brought in the employment discrimination context. Courts consider the employment relationship to be a contract, even at-will employment. If you're an employment litigator, you're probably aware that there are some key differences and some key reasons why a plaintiff often will bring a 1981 claim alongside their Title VII discrimination claim or instead of their Title VII discrimination claim. And some of those key differences, as I mentioned previously, that Section 1981 is race only. It applies to intentional race discrimination only. So, there's no sort of disparate impact theory under Section 1981. It applies to independent contractors. So that's obviously an important distinction. And Title VII applies to employees. Another big thing or kind of in the plus column for Section 1981 for plaintiffs is that there are no administrative hoops to jump through, like filing a charge before you're able to kind of litigate your claim. You can go straight to court on Section 1981 claims. And there's also no damages cap under Section 1981. As a result of this, sort of close connection between Section 1981 employment discrimination cases and Title VII employment discrimination cases. Courts have routinely borrowed, from Title VII. For example, in Section 1981 cases involving employment discrimination, courts tend to use the McDonald's-Douglas burden shifting standard to analyze, the claims of those individuals. And if we can go to the next slide. It's important today to recognize, though, that we're not necessarily talking about Section 1981 in the employment context, right? Section 1981 applies much more broadly than just employment, and it's applied in a variety of contexts where contracting activities are involved in. And some of the types of cases you might see include cases involving serving patrons in a restaurant, or selection of contractors for construction projects. There are also cases involving denying minority house hunters who are, looking to rent a property and being discriminated against, or allegedly discriminated against, based on their race, if they get denied those opportunities. Similarly, there are franchising cases, a few of which we'll talk about a little bit later, involving discriminatory practices, that are brought by franchisees or prospective franchisees, for example, only offering franchise opportunities in poor neighborhoods, or not offering, otherwise offering the programs on the same terms as white franchisees, for example. And then for retailers, there's racial profiling cases, right? And so there's theories out there about, if someone is racially profiled in your store, they're not having the same opportunities to sort of kind of enter into a commercial transaction with you on the same terms as in many cases of these cases are brought white patrons. And so as you can see, where these cases sort of Section 1981 sort of goes well beyond just the employment realm, despite the fact that most of the cases that we see on dockets related to Section 1981 are in the employment realm. On the next slide, you'll see that one of the the principles borrowed from Title VII, or potentially borrowed from Title VII in Section 1981 cases, is voluntary affirmative action. Again, I want to emphasize we're not talking about employment law today, but this is an important one because this is, again, an area where Section 1981 has explicitly borrowed from Title VII in the employment context. So when there's a Section 1981 employment discrimination case, there are cases out there that apply this voluntary affirmative action safe harbor to Section 1981 cases. And again, for those of you who are not employment lawyers, or maybe you don't practice in the space a lot, the basic tenets of the Johnson case and the Weber case, which we have cited many times, especially in recent months, is that in order to kind of avail yourself of the safe harbor in terms of your voluntary affirmative action plans in the employment context, those DEI programming, that DEI programming needs to be designed to address the manifest imbalance in traditionally segregated job categories. It must be limited in duration, and it must not unnecessarily trammel the rights of the majority. So courts have made clear, like I said, that this safe harbor applies in employment cases and education cases brought under Section 1981. But it remains to be seen whether that sort of those same principles would apply when we're not talking about an employment discrimination case, right? And so because of the close ties between Title VII and Section 1981 in the employment realm, it's clear that it applies, but again, we're not sure when we sort of look beyond and into the kind of that broad universe of non-employment cases that a court would look and say, you know what, we're going to also allow for this sort of voluntary affirmative action which, as we'll kind of talk about in a little bit, that's sort of where the supplier diversity programs and a lot of the questions we're getting around them, whether that same protection applies is kind of the question of the day. And so in the next slide, we'll see kind of in an analogous context that this question has come up, right? And so there's this General Motor case, which involved a white-owned business who brought an action against General Motors and basically just claiming, again, pretty straightforward case, claiming that they weren't able to purchase a local automobile dealership and that preference went to minority-owned businesses. So this, would be what we might call a reverse discrimination, Section 1981 case in the franchising context. And the court in that case, posed this hypothetical, right? And it is essentially that, and I'll just go ahead and read it, which is, what if a white prospective franchisee sued a franchisor which, acting in accordance with its affirmative action program or set-asides, rejected that white person's application in favor of a minority franchisee? Given that cases involving governmental entities do not apply because a franchisor is a private entity, could the white prospective franchisee nevertheless succeed with a 1981 claim? So, the court sort of posed this hypothetical and then, unhelpfully did not answer it. But this is the very question that we're sort of dealing with today, right? How are courts going to look at, this idea of voluntary affirmative action and having these programs geared towards, increasing supply diverse chains? How are courts going to analyze that? And the answer, again, is not really so clear outside the context of employment discrimination cases. If we can go to the next slide. So here's a case the Section 1981 case that we sort of see that doesn't, frankly, give us a lot of answers to that question, but shows us that some courts will just kind of sort of completely sidestep that issue for one reason or another. And in this case, again, straightforward facts. A prospective non-minority contractor was denied a security contract with a school district, and in that case, the court, I guess one of the more noteworthy parts of the case is that the court has no real discussion of kind of this affirmative action application, when we're dealing again with a reverse discrimination Section 1981 case in this context. And there was plenty of evidence here where there were statements by the superintendent and conversations among folks in the school district about why a black firm was not selected, and essentially the court and looking at this really just analyzed kind of very straightforward and in a direct manner whether there was direct evidence of discrimination. And there was also an interesting discussion about whether a business of this sort, is kind of this small business, can have a racial identity, which the court ultimately came down that it could. But that was really kind of the bulk of the conversation from the court. There was no real discussion about, well, if the school district has this program where they're trying to increase their diverse suppliers or diverse contractors, how does that sort of jive with Section 1981's prescription of race discrimination? And so again, this shows that a court can, again, completely ignore that analysis and just kind of move forward without addressing it. And again, it could also just be that the defendant in this case just didn't raise that argument. But we'll see on the next slide a case where the defendant did actually sort of have this issue come up, and the court did actually have the opportunity then to analyze it. It's an older case from 1993. And in this case, Chrysler is the defendant. They ran two different programs sort of aimed at increasing diversity among their dealership owners. One was, to sort of pump in resources into geographies that didn't have lots of folks with capital that could sort of start up their own dealerships. And so, part of it was to sort of help by actually employing individuals to run their dealerships and particularly, I think, diverse individuals to run their dealerships. And then ultimately over time, the idea was that hopefully that, as Chrysler owned those dealerships, that these folks who participated in this program could sort of buy Chrysler out over time and sort of run them independently. And then there was also this minority development program they developed to sort of have this be a pipeline into this as a marketing investment program. And of course, a white plaintiff sued. She brought her claims under Title VII and Section 1981 because of the MIP program was actually sort of you were employed by Chrysler during the time that they were sort of helping you run it, and there were benefits and things like that. So there was a Title VII aspect to the case, but also she brought her claim under Section 1981 due to the contracting portion. And the court in this case, and Chrysler sort of argued, well, this is a voluntary affirmative action program, and the court did a sort of a fulsome analysis going through each of the three prongs of the Johnson-Weber test that I described earlier, and ultimately ruled in favor of plaintiff, granted summary judgment in plaintiff's favor, essentially finding that the program was pretext for discrimination. And the reason for that is that Chrysler did not point to any real manifest imbalance in their dealership ownership that would point to them being able to have such a program, and that they just kind of were winging it in terms of saying we think there's an imbalance here, but there was no real analysis done to determine that. And so because of that, they lost his case. But again, the sort of upshot of this is that it shows that while this isn't a supplier diversity case necessarily, it does show that in Section 1981 contracting case that it was not, not only, I guess, an employment case, that the court was willing to kind of take a look at these Johnson and Weber Title VII voluntary affirmative action principles and sort of apply them to this case. Of course, as I mentioned, there was a Title VII aspect of this case, and that could be partially why the court was willing to sort of pull that in, given that that count was there. But it shows that it is at least not something that's going to get laughed out of court. And that is an argument that that may be worthwhile to make for employers who have these supplier diverse programs, as long as you can actually meet each of the three prongs. And so in this next slide, you'll see I just pulled some language from supplier diversity programs that's out there, and I think the important point about all this is that you can see, this is something that companies are talking about. This is something that companies are sort of marketing and sort of being out there and loud and proud about. And so, the question then comes up is, how are courts going to sort of view this, right? This is the type of language, circumstantial evidence, for example, that someone might point to in a Section 1981 case, right? And then, the language in these programs is sort of akin to what we saw in Chrysler, for example, of demonstrating a desire to sort of fix what I imagine many of these companies view as an imbalance in their supply chains. but whether that is going to be enough under these voluntary affirmative action standards, and as Annette mentioned earlier, whether those standards are even going to survive in sort of a post Students for Fair Admissions world is again kind of the $1 million question that we spend a lot of time thinking about every day here. And so with that, I'm going to turn it over to Barry. But before I do, I want to make sure that I'm able to get the CLE code out for everyone. So the CLE code is SS, as in Seyfarth Shaw, 4714. That's SS 4714. And with that, I will turn it over to Barry to talk about the practical implications here. Oh, and Barry, you're on mute.
Thanks, Brennan. I'm going to talk about some of the work that we're doing in the trenches with some of our organizational clients following the Supreme Court case, and the measures that some of these organizations are taking both to insulate themselves against some of the impacts that Annette described, and in some cases, even to leverage provisions of the Students for Fair Admission decision to potentially bolster and undergird some of their supplier diversity programs. Before I dig into the meat of that, though, I picked up a couple of questions out of the Q&A that I think are worth responding to. One of the questions was about whether this is solely a question of federal law or whether there are state laws that could be implicated by these supplier diversity programs as well. And the answer to that question is there are state laws on this subject. There are a number of states that have statutes that don't have the same historical background that Section 1981 does. That hasn't really been described in detail in this webinar, but the gist is it's a post-Civil War Reconstruction statute that goes that far back. We have state statutes that have been enacted much more recently and entitle people to contract in the economy and in the market at large and not be discriminated against, not only based on race, but based on other protected classifications. Because one thing that is a standout consideration for Section 1981 is it only applies to race. There's no gender theory or any other theory that you could pursue. And there are no other federal statutes that would create a similar sort of claim. But that doesn't mean that it is carte blanche when it comes to gender or religion or any of those other things, because there may well be state statutes that implicate this stuff. And because federal law is so new on all of this, we've elected not to try to do the even deeper dive into the state stuff. But if you're rolling out a diversity program, that is worth doing. One of the things that popped up in the Q&A is some activity in the Fearless Fund case that Annette mentioned. There was actually a preliminary ruling in that case yesterday, so I just wanted to clarify the status of that case because it is kind of a bellwether for a lot of the things that we're dealing with. And what happened yesterday is a judge in Georgia denied the plaintiff's motion for a preliminary injunction. And the popular media has said they won, Fearless Fund won. That's not really the case. This was the denial of a preliminary injunction in which the plaintiffs were essentially seeking emergency relief. And the judge has yet to issue a written opinion, but I would be willing to bet that it's going to say a lot about the nature of whether this is an emergency or whether it's the sort of claim that could be resolved by monetary damages, in which case an injunction is not appropriate. The takeaway there is that we're on day one of a very long fight, both with respect to the Fearless Fund litigation specifically and the larger issue more generally. So I just wanted to clarify some of those points. And Kate can take us to the next slide, which I think sets up the first question that organizations are faced with if they are sitting on supplier diversity programs that may have been enacted prior to Students for Fair Admission or were in the planning stages of doing that. And we've seen almost every possible reaction to Students for Fair Admission from all corners, including organizations that are very committed to their DE&I programs and organizations that may have been doing them for other reasons. You know, they may get a market boost out of doing DE&I work, and so they weigh the market boost that they might get out of DE&I against things like litigation risk. And so we see some very interesting reactions. some organizations, and Fearless Fund is sure one of them, is not backing away from the diversity programs that they've put in place even a little bit. And I've worked with a number of employers that are taking that same posture, and they're saying, we're going to do this because we believe it's the right thing to do, or we have other commitments to do it. And so the only real question is how best to do it and whether we can insulate ourselves a little bit, which I'll talk about momentarily. But that quote that you see there is from one of the founders of Fearless Fund, who obviously is not going to be cowed by the claims that are pending currently. We've also seen people back away from their diversity programs and put their pencils down in a pretty surprising fashion. And what the Small Business Association has done in the Ultimate Services case that Annette described is just that. They've shut the program down and walked away from it because in that case, an injunction actually was granted. But one of the most interesting reactions that we've seen, and you'll see this theme kind of perpetuated in some of the slides to follow, is organizations that are continuing to do what they think they should do in the diversity space, but pulling back from a lot of the publicity associated with it. Historically, referring to recent history for sure, but prior to Students for Fair Admission, there are a lot of organizations that saw at least two benefits from a diversity program. One is you get to diversify your constituency, and you might get people with different experiences and skill sets who can help your organization do whatever it is your organization does. The other benefit is it looks good. There are PR points to be garnered, at least in certain corners, from having diversity programs of various sorts. And one thing that I've seen that's been really interesting is organizations that are putting that side of the equation in a closet for now and saying, we're not going to be out in the market bragging about this diversity stuff that we're doing because it makes us a lightning rod, but we're going to continue doing it, which is an interesting response. And we've seen some of these organizations even take down their historical materials describing their DE&I efforts, their annual reports and those sorts of things, while they continue to retool those programs. Pete, can you take us to the next slide, please? So one thing that I think is important to recognize is that there are little kernels in the Students for Fair Admission decision that may provide some guidelines for an organization that wants to continue to have a supplier diversity program, but doesn't want to get in the way of oncoming litigation. And one key point that the majority recognized in the Supreme Court case is that diversity is a legitimate goal. The holding of Students for Fair Admission does not begin to suggest that diversity is not a legitimate thing for an organization to pursue. And they recognize that in the college context anyway, bringing people into an organization who come from different backgrounds and have had different life experiences is worth something. And so it's a legitimate thing to pursue. The holding of the Supreme Court case is you can't pursue that goal by assuming that people with a given race have other attributes that would be a positive contribution in terms of skills and experience. But you're still allowed to pursue that diversity in other ways, and the opinion talks about this quite a bit. So we've seen some innovative organizations reach out and kind of adapt the college admissions model to their supplier selections process. And so instead of collecting information about the race of the owners of an organization, what some of those organizations are doing is beginning to collect other narrative input from potential vendors and suppliers about who they are, where they came from, and what they've accomplished. And you can even lay those questions out in a way that is intended to solicit information that is going to get at that diversity of experience. And one thing that illustrates this sort of subtle point is a notion of connecting a given vendor to a community. That's long been part of the diversity conversation. You hear people say things like, we want to look like the communities we serve, which I think following Students for Fair Admission is a dangerous thing to say, because what that decision essentially concludes is you shouldn't be drawing any conclusions based on what people look like. You should be looking at their attributes. But one of those attributes is going to be their connection to the community at issue. So if you're looking for a supplier in a particular community and you want that supplier to look like the community or have connections to the community, that's the question you should be asking them. not what the race is, but what is your connection to this community or this type of community, like a dense urban population, that sort of thing. And in that way, you can ask completely legitimate questions and promote diversity without tripping these wires that may precipitate a race discrimination claim. And I think that where organizations are doing something like that, in addition to retooling the process, you want to document the selection decisions that are made and the reasons for them. And if you're in a position to say that we've selected this vendor because they have a particular diversity of experience, which you could identify in writing, and we think that's going to contribute to our organization in some way, the internal logic of all of that is not really something a court can second guess. And if you're able to justify a decision you've made based on a trait of the person you've selected or the vendor you've selected, you'll be a lot better off in defending that in court, as opposed to allowing people to operate on suppositions potentially that you may have selected a vendor for an impermissible reason. The next slide talks about another kernel that is in the Students for Fair Admission decision. And one of the reasons the Supreme Court struck down affirmative action in the college admissions context is that the court concluded that looking to race is actually not a very good way to promote diversity. At least it's not the only way. And in the context of the constitutional scholarship on this and Title VI, you have strict scrutiny, meaning that it's on the organization to show that whatever they've done is the best way to accomplish a given goal, or the only way to accomplish a given goal if they're using race as a overt factor in that analysis. But there are things that one can do as an organization to promote diversity without saying anything about race. And we see that sometimes when the contracting and procurement folks start talking to the lawyers, and you start getting information from the procurement folks about what the existing vendors look like and what is keeping certain vendors out of the mix. And you see a correlation oftentimes between smaller businesses and businesses that are run by folks from diverse backgrounds, including racially diverse backgrounds, which was the whole point of the Small Business Administration program that we've mentioned a couple of times along the way. And it is, in my view at least, certainly permissible to do things that are going to make it easier for a small business to contract with your organization as compared to, say, a larger business, without implicating any race issues whatsoever. And I've worked with some organizations that have opened up their standard contracting terms and looked at those sorts of potential barriers to entry. And they might think about something like cash flow for a smaller organization and whether they can do something, for example, with the credit terms in an agreement or the payment cycle or the insurance requirements, which might pose an artificial barrier to entry. And if you tinker with those, you may be able to diversify your supply chain, again, without ever even mentioning race. You're just trying to promote different types of suppliers who have various characteristics they can bring to your organization. But I'll emphasize again that that really does require the input from your procurement folks, because lawyers guessing about what particular types of businesses might want or need is not a great way to solve that problem. Another thing that I would add in this vein of things that you can do that will promote diversity or may promote diversity but don't trip this discrimination risk is that outreach remains entirely legal. You can continue to reach out to any organization that you think may bring potential vendors to your doorstep and pursue those opportunities to let folks know about an existing contract that may be available, so long as you don't take race into account in selecting the vendors. Put differently, you can pump all kinds of information out into the world, potentially in a selective way, to influence and expand the pool of vendors that may come to you. And in that way, diversify, potentially, your pool of potential vendors without making any necessary race-related decisions in that process. And the last thing that I would add on this notion of practical things that you might do to increase diversity in your supplier base is think about what is causing your most entrenched and largest suppliers to remain that way. And you can, for example, imagine a term that provided preferential pricing. If you have a megalithic vendor and you're buying massive amounts of stuff from them, you may be getting it at a super discounted price. And that may mean that other smaller vendors are effectively excluded from the market and unable to compete. Obviously, there are business consequences when you decide to drop your super cheap megalithic supplier, but it is something that a lot of organizations are at least given some real thought to, given the other restrictions that may come to play in this space rather. The next slide emphasizes something that really comes through in a couple of the cases that Brandon described for us, which is that all of the fancy tricks that we may think up for you to use in diversifying your supplier base are going to do you exactly no good if the folks who are administering those programs and out there in the world talking about them are saying things that are inconsistent with the design of your program. And that has happened over and over again, and it's certainly not unique to the supplier diversity space. That is kind of what employment litigation is all about. Employment discrimination litigation is all about. And one thing that a plaintiff is going to want to do is impute a motive to your organization that is impermissibly based on race. And even if your documents are perfect, if your executives are out there saying something that is not going to comport with those documents, you're going to have a problem. And I think there's at least a two-prong approach that's necessary in responding to that. The first is there's always a lot of collateral, written documents, web pages, all that sort of stuff around these diversity programs. And really every such publication should be reviewed following the Students for Fair Admission decision, because there's a lot of language that historically may have been used more loosely that really should be scrutinized at this point. And what I've already mentioned is a phrase that we hear a lot in this space: we want to look like the communities we serve. We want to look like our customers, those sorts of things. Those statements probably need to be eliminated. Similarly, we want to help Black-owned businesses. We want to help minority-owned businesses are going to be potentially problematic, because a plaintiff is going to claim that that reflects a motive by the organization to contract with Black people or Hispanic people, but not white people. And that is going to be actionable. And I've now had the opportunity to plow through dozens of these documents in which an organization is describing its own diversity programs and supplier diversity programs in particular. And it's a really delicate exercise, because there are things that an organization is going to be very motivated to say, and sometimes to say in a particular way, that just have to be tooled to deal with litigation risk. And there's a lot of push and pull in that process. Typically, there's a number of constituents, so it's a little bit of a political exercise too. But you need to balance the overall language of the document with the notion that it may someday be used against you in court. Related to that, in addition to whatever you're doing with your documents, I think it's critical to provide some emphasized training to the people who are going to have responsibilities for executing these programs, so that they not only know what they can and can't say about these programs, they really need to know why. They need to understand a lot of the concepts that we've talked about here today, even though they are legal concepts, because the things that are permissible to say are very close to things that could give rise to litigation. And so they need to understand some of these concepts that we've talked about, such as not assuming that people have particular traits based on their race, and such as focusing exclusively on the organizationally relevant traits that somebody may have in describing why we've elected to contract with this person versus that person. I can't emphasize that enough. It's an easy miss, but that's where most of your lawsuits are going to come from. It's from people saying the wrong thing. And the last slide that I have on this topic is a little bit more cutting edge. We have a state of play in the legal landscape right now that is extremely uncertain. The cases that Brandon walked us through and the quotes that Annette highlighted from the Students for Fair Admission decision provide scant guidance, just tea leaves really, as to what ultimately, in a few years' time, is going to survive litigation and what's going to result in a judgment. And some of the stuff that I've talked about already is very keyed into those things. And so we have a higher degree of confidence that those measures are going to do you at least some good in insulating a supplier diversity program. This last slide is kind of out there on the edge, and it is intended to get folks thinking about what we may do to defend a diversity program in something like the employment context and translating that into the supplier diversity context. I'll say again, by way of disclaimer, not clear that that's legally going to work for you. The law is just not settled on that point. But we've had an opportunity to work with some organizations who have undertaken to do it and to assess what their supplier pool looks like in comparison to their competitor supplier pools and to the pool of available vendors in the market that they share with their competitors. That's the sort of thing that we would do in the employment context all the time. And there's essentially an existing structure for that that's been around for many years. But it's much, much harder in the supplier diversity context because the data is much more difficult to delineate. When we do it in the employment context, we have census data that we can use that tells us about people's education level and racial demographics and all that stuff. Interestingly, if you poke deeply enough at the census, there's information like that on organizations as well, and people who hold certain roles within organizations. And so we've played around with using census data and other data sets to measure the diversity of a supply chain and then build an argument that it could be further diversified, and that would be consistent with certain legal principles. I will say that the analyses we do are just inherently more subject to attack because this process is less settled. And I think oftentimes what you're going to set yourself up for is dueling experts in litigation, with the organization's experts saying we had an observed disparity, it was a problem, and our program fixed it, and the plaintiff's expert saying there was no disparity in the first place, and what they've done amounts to just furthering racial discrimination. That's not the sort of litigation most people would want to bring on themselves, but if you're sufficiently committed to your diversity program, it's worth at least thinking about doing the statistical exercise. That's a longer conversation unto itself. The last thing that I want to throw out there is the notion of having a supplier diversity program that is more an annual than a perennial. And one thing that continually shows up in the reasoning in Students for Fair Admission is the notion that any diversity promoting program has to have a discrete and defined endpoint. That was one mantra that's repeated in the Supreme Court's opinion, and one thing that they found lacking in these university admissions programs. And so one very basic thing to do is to start thinking about a diversity program with a discrete life that might be replaced by another diversity program with another discrete life. But defining an endpoint for any of these programs that you may decide to roll out is also something that's going to be very helpful to you in a variety of ways. It may help you avoid the sort of scrutiny that you see in the Students for Fair Admission decision. It may also serve to cap damages if you've got a program that's only of discrete duration. I throw these things out there just because they reflect a couple of ways that you might radically rethink how you're approaching supplier diversity, where we're sitting on a legal landscape that is brand new and entirely unsettled. So I hope that these observations have been helpful for folks, and I will turn it back to Annette to wrap us up.
Yeah, so thanks. Just a couple of questions that came up on the chat that wanted to quickly address. There was a question about transparency, where public commitments have already been made. What are we seeing? And I will say that that is an area, whether it's on the employer diversity side and employment issues or supplier diversity issues, we are seeing employers taking a very close look at how they have positioned their policies and practices. Frankly, oftentimes the communications are written more from a communications perspective and have you know, more glowing or progressive language. And so that is an area where we are seeing employers taking a close look to make sure, number one, that they're what they are doing is accurate, and you know, making determinations on whether they do have to scale things back, and if so, what they're sharing externally is really important in that context. So with that, we're right at the top of the hour. We thank you so much for participating and joining this discussion. Definitely more to come. And yes, we will be circulating the deck as well as the recording following this presentation. Thank you so much for attending.